Okay, we're back, and it's time to talk about confidentiality and privacy. Now, clients have the right to personal privacy and confidentiality just like we do, right? Personal records, clinical records, verbal communication about their conditions and things, all things that are considered to be confidential and private. As a caregiver, you're going to come to know private and confidential information about your client, and it's your responsibility to protect it and act in the best interest of preserving the privacy and the confidentiality of the knowledge that you acquire. Okay? You're using this knowledge for good, not for bad. It's not for gossip, it's for helping. So, as far as communicating things, it's communicates what's needed when it's needed. Okay. All right. Protecting client privacy. There are several ways that you can protect your client's right to privacy. Some examples might include knocking and waiting to be invited before you come in the room. Just because you're there 8 hours out of the day doesn't mean that it's just okay to barge in anytime the client's got a door closed. You Making sure your client's not exposed to public view during personal care. Keep them covered as best as you can. Minimize exposure throughout the procedure. Don't take pictures or videos or recordings of your client unless they want you to. Hey, would you mind taking my picture beside the Christmas tree? Or, hey, I just got this new puppy. Can you take a picture of us? Obviously it's okay if they request it, but not just like snapping photos. Go, oh my gosh, look at this guy. See how big he is? No, not like that. Making sure the client has privacy during communication, like meetings and telephone calls, and opening their mail, just things like that. What's normal and expected that you would appreciate. Now, with keeping information confidential, remember the clients have a right to their clinical and personal records maintaining confidentiality. This includes information about their living arrangements, medical treatment, their finances, the personal care they get. All those things are something that care team members should follow confidentiality laws about and use professional ethics when discussing. It will come up in conversation. Sometimes it'll be necessary to talk about these things, but we talk about them when it's in the client's best interest and when it's necessary. Good. So protecting someone's right to privacy and confidentiality is the basis of your professional relationship. Okay? They trust you, and you earn and keep that trust by not running your mouth about things that are private to them. That's not to say if there's something you're concerned about, then you don't say something, because of course then confidentiality goes out the window because client health and safety comes first. Everything is a check and balance to something else. Now, you share only what's needed, and I keep saying that, right? Don't gossip. I already said that. And do not have discussions in public areas where other people may overhear. Simple guidelines. Now, you may not share confidential information with other people outside the care team without written permission from the client. There needs to be some sort of documentation that the client says, it's okay if you talk to your mother about my case because she went through what I went through a few years ago, and maybe she'll have some insight or some help or whatever, and maybe they're going through something and they say, yes, you can talk to. They can't just tell you it's okay, because they can rescind that just as fast. If you come back with saying something they don't like to hear, and suddenly it's like, well, they blabbed to their mom about this, and now they're all up in my business, and their mom's trying to call me, and suddenly you got drama you didn't want. Written consent if you're going outside the care team for any reason. And you should let the care team know you're doing it. Just be on the safe side. The more people in the loop, the better to protect you. If someone outside the care team asks you to share information about the client, just direct them to the client and say, I'm not at liberty to say. You can talk to John. He'll tell you everything. Never talk about a client outside of work, even if you don't use their name. Casual conversations can jeopardize someone's privacy. Oh, that one client I have, I can't say her name, but you know who I'm talking about. No, that doesn't fly. You're still breaking confidentiality. Now, there's something called the HIPAA Act, the Health Insurance Portability and Accountability Act, HIPAA, and that's just a federal law that regulates the use and disclosure of health information. Basically, it says that when it's required and when it's not, and when it's necessary and when it's not, that sort of thing. Okay? But HIPAA laws are pretty important, and you'll need to know what HIPAA is for the test. So just remember what HIPAA is if you're not sure. Now, people who have interpreter or translation needs, they have the right to those services at no cost and without significant delay. I'm not going to say it's easy to get those services without cost and with no delay, because you'll have to jump through some hoops, but they have the right to that. You see? That's the difference. All right. In a perfect world, of course. All right, now let's go flip over to page 68. And we're talking about resident rights. People who live in long-term care facilities have additional resident rights. These are specific rights to make sure that even though they're not in their own home, they get care in the way that they would if they were in their home and in a way that enhances their quality of life. It gives them the right to courtesy and dignity and recognizing their individuality and their identity. So their basic rights are their basic legal rights. They lose none of those when they go into a facility. They can exercise their rights. They're not supposed to be intimidated, forced to do anything, discriminated against, or punished for it. Okay? These are basic human rights. Everybody has them. But they have the right to know information concerning themselves and the facility in which they live. The facility has to provide this information if they request it. They can't hide or obfuscate this information. Now, the residents get information before they even move in. They'll get information like what their rights are for the residents, their resident rights, right? The rules and regulations, so what their responsibilities are, what they're supposed to follow, and what's expected of them. Availability and cost of services, items, and activities. Not everything's free. Sometimes there's an extra cost to participate with something or, eat a certain type of food or things like that. And then how to contract an ombuds and file a complaint, just in case there is something wrong that they need to have an advocate for and they don't know how to fill out the proper paperwork or, finding the information. Now, the facilities are also required to notify residents of changes that affect them, like availability and charges or services, changes in rules. They cannot change one of these things without notifying their residents and in some way, shape, or form obtaining like something in writing or signed that says that I understand that these changes have taken place and I agree to abide by them. They cannot change the rules on you and just be like, well, you know what? You live here. You got to abide by the rules. No back talk. Not like that. Now, the residents also have the right to some faculty records as well. Sorry, facility records as well, like inspection records, plans of corrections, and even their own personal records, including clinical ones, within 24 hours. So those are things that the facilities normally keep ready to go. They oftentimes even have paper backup copies just in case the system's down or the internet's down or something like that. They'll have a paper copy and a hard copy file in many cases so that the client can see it if they need to. Think about some ways you can support people's right to information. I don't know, maybe you have some ideas. Comfort and security. Residents have the right to a safe, clean, comfortable, and home-like environment. The facility has to meet their needs and honor their preferences as much as possible. They can't cater to their every whim, but as much as possible, just like you do, as much as possible for your clients. Residents have the right to privacy in their room, the ability to lock their door if they so choose. They have the right to remain at the facility and never be kicked out without some sort of really appropriate reason, and a 30-day notice unless it's urgent. Okay? So, no booting people out unless there's a good enough reason. And even oftentimes, if they don't pay for their residency there, a lot of times they won't even kick them out for that. They'll be like, well, we can't throw them out on the street just because they're indigent, and they'll try to find a way to work with them and things. So there's a lot of protections in place for people that live in these facilities. All right, that being said, let's move over to page 69 now. Okay, top of the page. Communication and visitation. The resident decides who they interact with, don't they? Because they have the right to participate in meetings and gatherings and get-togethers and things like that. So, of course, they can decide these things. The facility must allow visitors that the resident wants to see when they want to see them. Okay? There may be set visiting hours at some facilities due to staffing levels and things like that, but that would be something that they would be told before they even move in, and something that they would have agreed to before moving in. But most places, there's open visiting hours, just like you would at home. If someone wants to come visit you and you want to see them, by all means, knock, knock, come on in. If the facility believes a visitor endangers others, then they have to work with the person and explain why and come up with a plan to help keep people safe. Obviously they can't just let anybody in, especially if they have prior bad behavior or things like that, or inciting violence or causing problems. So, obviously some discretion has to be made. Um, what would be some situations where you think they could decline somebody from coming in? Take a break, think about that, and we'll come back here in just a second, okay? Okay, resuming. Remember, the facility has to get the consent of the resident before limiting visitors or anybody who wants to come. And that's anybody, friends, family, doctor, anybody on the care team. If they want to limit a visitor from coming to see the person, they have to get the consent of the person and explain adequately why. All right. Other than that, if there's a problem, they just have to call the police and let the police deal with it. They can't just bar somebody from the facility if there's no good reason why. The resident also have to allow the ombudsman to examine their clinical records. So if they have a grievance about the fact that they're not letting the person in, well, they have to let the ombudsman in to have the person file a grievance against the reason. Maybe the son causes trouble when he's there, or maybe he does inappropriate things, but the mom doesn't realize it. Maybe he's walking to go visit his mom and he's like hitting on the nurses and he's slapping people's butts and he's stealing things that are lying around. And then he goes in to see his mom and, oh, he's the sweetest boy. But the facility's like, he can't be here. They have to, find a way around that. They have to find a way to get him to not come and make sure the ombudsman understands the reasoning behind the decisions. All right. So to make sure that somebody has an opportunity to communicate, they have the right to send and receive mail. Have access to paper, pen, and stamps at their own expense, of course. So they don't provide these things, but if they say, I need these things, here's $25, please pay, then by all means, they provide them. Having access to telephone and privacy while using it. So those are basically the most important things about the communication. Now on to property and finances. Well, what do they have? Whatever they walk in the door with, unless it's a clear violation of policy to own or have that thing, such as drugs, firearms, illegal substances. Maybe they have a 12-foot samurai sword and they're swinging it around all the time. I mean, within reason, they can have pretty much whatever they want, but there will be things that are outlined in policy that say these things are not allowed at this facility. And they have to agree to it before they move in. And if they violate it, then they're violating an agreed upon policy. But for the most part, if it's your property, it's your property. Hippity hoppity, leave my property. They have the right to keep their personal possessions in a safe and reasonable manner, have their possessions treated with respect, and keep and manage their own finances. So they don't have to put their funds into the facility and then let the facility run them. Now, there's cases where people will elect somebody to manage their finances. And in that case, as long as it's all above board and legal and everyone knows what's going on, then it's perfectly fine. You may be asked to help handle their finances, check their bank balance, help them balance their checkbook, manage their money, create a budget. Those things may be trusted to you as a caregiver, and that's perfectly fine, perfectly legal, as long as the client is aware of what you're doing at all times and the rest of the care team knows that you're helping manage their money. This way, if money ever goes missing for any reason, there's no reason to suspect that you had anything to do with it because you were completely above board and documented everything. Protect yourself. Finally, grievances. Remember the written complaint? They have the right to make the official grievances about services or lack thereof, and they're prohibited from punishing somebody for making a complaint or report. Another thing that sometimes I've seen in large facilities, people who complain, they don't get the best treatment. And so that's another reason that I like the home care setting, because typically if someone's going to complain about something, usually there's a reason behind it, because people who are in the home care setting, they know if they complain unreasonably about things in an excessive manner, they'll get a reputation as somebody who's crying wolf about something that's not real. And they're going to know that if they do have something happen that's real and they have to talk about it, people are oftentimes going to go, well, she always says her caregivers steal from her, so why would this be any different? I don't believe her. Whereas in a residential facility, it's sort of flip-flopped around. A lot of times the resident, the faculty has the power. And they say, oh, the resident said this or that or whatever, but they oftentimes will say, oh, no, this never happened. And the faculty will kind of stick up for each other, and then it lets them get away with some less than scrupulous behaviors. So again, I'm not knocking the big centers. I'm just saying that I've heard that it happens, and that's one of the reasons why I prefer home care setting to big facility setting. Now, how about grievances? What else? What else about grievances we got? And that's right. They have the right to a hearing And if they disagree with the decision about the grievance, then they can take it to the next level. Now, if this scenario happened, somebody complained to you about the care they're receiving, what would you do and what kind of answers would you make here? Think about that, write a few little things down, and we'll talk about that in class. But for now, let's scoot over to page 70. Over to page 70. Ooh, here we go. Now we're talking about legal protections. Clients have legal options and access to organizations to protect their rights, of course. And you have to be familiar with and understand these resources. We already talked about advanced directives, right? What it is, the set of instructions, but there's a couple types. There's living wills that say, if I'm incapacitated, this is what I need you to do. There's powers of attorney that put another person in charge of that person's legal decisions. And then there's anatomical gifts that basically say, if I die, I want to leave this to science or to a donor or not a donor, to a recipient or something like that, if you want to donate something. These documents would represent their wishes and can only be made or canceled by the client. Even the power of attorney stuff. If they say, oh, I don't want to be an organ donor, the power of attorney can't go, yeah, you know what, they're going to be an organ donor. They're not allowed to make those types of changes. They can only make new and oncoming changes, not changes to previous decisions. That's an important distinction. So a living will is basically the client's desire to receive or withhold life-sustaining procedures. Remember, we talked about if they need CPR or resuscitation of some sort. Living wills also would say if they want to be on life support or not. So important decisions, aren't they? Life or death decisions we're talking about that are outlined in living wills. So again, if you don't know if your client has advanced directives of any kind, find out. You don't want to violate one of these unknowingly. The powers of attorney and durable powers of attorney, basically they mean about the same thing. One of them is sort of more temporary and one of them is more permanent, okay? But they mean it basically the same thing. Someone else is in charge of making my legal decisions while I can't. That's basically what the power of attorney is. Then you've got the durable power of attorney for healthcare. That one lets somebody make the client's medical decisions, not just their where does my money go, who pays my bills, who's going to divide up the house. It's more like what's going to happen to me health-wise. If they're in the hospital and they're incapacitated, but they're going to wake up. Well, they're not going to have a living will doesn't really apply to that. But what if they slip into a coma and they don't have a living will? Well, that's where the durable power of attorney for healthcare would come into play. That person would decide, I'm her son, I'm her, durable power of attorney for healthcare. Please put my mom on life support for 6 months, and if she's not, then pull the plug, something like that. It's important to know that this doesn't mean a lawyer. Durable power of attorney doesn't mean a lawyer. Anybody can be a durable power of attorney if designated so by the client and the proper paperwork is filled out. Okay, just important designation. Now, what's a guardian? Let's go jump over now to page 71. Okay, page 71. And we're talking about guardians. This is with an adult client is incapacitated. A legal guardian can take responsibility for their interests. Okay, and this is more of like a permanent thing. Okay, the guardians would be responsible for acting in just the best interest of the client all around. Okay, they may be incapacitated and they may have periods of lucidity where they can make decisions and then they can't, but this doesn't rescind anything like the powers of attorney does. They would remain the guardian even if they were better until the client decided they didn't want them to be the guardian anymore. It's not something that comes and goes with the condition of the client. So that's the difference between living will, power of attorney, durable power of attorney, healthcare, and guardian. Hopefully that makes sense. I know it's a lot to juggle. You don't need to know all these differences. You just need to be familiar with some of the differences so you could pick out one versus the other. So if you're not sure, go back and review the book a little bit. Go back and read through it, maybe highlight the key points that you can tell the difference of. But you will need to know the key points of how they're different. All right, so what's a POLST form? A POLST form is not an advanced directive, but it's darn close to one, because it's a summary of the client's wishes involving life-sustaining treatment. Okay? That one is just the life-sustaining treatment. Do I want CPR? Do I want to be on life support? All that. The advanced directives are much more encompassing. They encompass a lot of things, but this one's pretty much just for, do I want to be kept alive if I'm supposed to die? If it's my time, do I want machines to keep me alive? Do I want some person pounding on my chest to keep me alive? Right? So, think about that. Think about maybe you putting together a post at some point. It might be a good idea. And we'll take a little break here, I guess, and we're going to come back in a few minutes and pick up at the top of the page. Okay, and we're back. So let's now discuss the signed post form. The signed post form represents the client's wishes and the physician's orders. They usually do these in conjunction with their doctor. Nobody just sits down and fills one of these out by themselves unless they really know what they're doing. Usually they'll consult the doctor and talk about it so they can have informed consent about what they're really agreeing to here. So you can pretty much trust that a post is going to be legitimate, that it has been discussed and it has been decided upon. You want to make sure you have this available. It's normally printed on bright green paper in Washington State, and typically people will slap them right on the refrigerator. So in the event that if something ever happens, paramedics or whatever, they can find it quickly. That's the first place they're going to look, is on a fridge. The second place they're going to look is you. They're going to say, does your client have a DNR? Do they have a pulse? Do they have advanced directives? They're going to ask you that if they're there for an emergency and the client is not responsive. So know about these things. Okay? Now, the DNR or the DNAR used to be called the DNR, but things change. The DNAR is the CPR one. It's basically specifically for CPR, and it's usually part of the post form, or it may just be a separate entity on itself that just says, I want CPR, I don't want CPR. Okay? Again, a good discussion to have when you first start working with a client, getting to know that. Why do you think somebody might not want to have CPR? Think about that one. Maybe write an answer down so we can just have an answer ready for when we talk about it in class. Okay? Now, how about responding to medical emergencies? In general, if there's an emergency situation, you must call 911. But the care setting you're in, like an adult family home or residential facility, might have additional things that need to be done in an emergency. Nothing would supersede 911. Emergency equals 911 in all cases. But there's other things that may come in conjunction with or even preceding, but not superseding 911, if that makes sense. For example, in the event that there's an emergency, your first priority should be to make sure the client is in a safe place so that whatever's happening does not worsen the situation. Okay? If they're having a heart attack or a stroke, the first thing you would do is you would, sorry about the low battery thing. The first thing that you would do is you would get them safely to the ground before you call 911, right? It takes seconds to do, but you wouldn't go, oh my gosh, you're having a heart attack. Beep, 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 and the client's falling on the ground. So there will be sometimes where things supersede 911, but they don't necessarily mean that they're, gonna take over. Hope that makes sense. So you have to understand the emergency policies and procedures of where you work, of course. Now, the difference is you've got hospice care. Hospice care is where people go when they're expecting to die. Okay? They're in their late stages of whatever it is ailing them, and they're no longer getting rushed to the hospital when they die. Then they're in the hospice care. They're expecting to pass away. It's where you go where you can be more comfortable while you're in the later stages of passing away. Okay? People don't typically stay in hospice for too long, but sometimes they stay for a while because you never know. I mean, we are humans and we're unpredictable. So when you have a hospice situation, you should normally have a policy in place for what to call if an emergency happens. Because even in hospice care, emergencies can occur that don't include the client dying. They can slip and fall and crack their head, and that's not how they plan to die. So that's an emergency where you might call 911, of course. But a lot of times hospices have really good medical professionals on staff that negate the need for a hospital in most emergencies. So it's, like I said, you check and you see, based on where you live or where you work. All in all, learn the policies about advanced directives and emergencies based on where you're working, and make sure you know about the posts and the advanced directives. We'll talk more about these in Module 12 too, when we're talking more about hospice. So now let's go ahead and flip over to page 72. We're almost done. This is the Ombuds Program. Okay? The Washington State Long-Term Care Ombuds Program protects the rights, dignity, and well-being of individuals, what am I saying? In long-term facilities. Blubbing here. The long-term care ombuds program is required by the Older Americans Act to have three things. It has to work to resolve complaints, it has to monitor state oversight, and it has to comment on proposed state laws and regulations. Basically saying if they're appropriate, if they're correct, if they're, that's that sort of thing. There's a network of 13 local offices across Washington state as of this book being printed. There could even be more now. Volunteer and staff ombuds visits thousands of facilities, I keep saying faculties, in order to ensure the residents' rights are being upheld and the services are free and confidential. So again, what a wonderful country we live in, that we have a service like this that's available to people who have nobody to represent them. These people go out, they hear what they have to say, and they make sure that their rights are fought for if there's no one else to fight for them. Heroes. Love it. Go ombuds. Now, what are the duties of the ombuds? Well, they advocate, they work for the residents, the families, the facility staff. They work with everybody in the care team, basically, to make sure that the needs are being met. They hear and help resolve complaints and concerns, grievances. They monitor laws and regulations and policies so they understand better than a lot of people what is and is not okay when it comes to providing and receiving care. They'll provide public education to promote better understanding about these laws and regulations. And they help to establish residence or family councils if there needs to be a group of people brought together to sort of help make decisions about the client's care. So they do a lot. How do people find these people? Well, accessing the Ombuds program would include people who are residents of nursing homes, assisted living facilities, adult family homes, all those types of places, relatives, friends of residents, long-term care facilities, administrators or employees of nursing homes. They need to know where the ombuds are so they can get them for their residents. Any group or individual concerned about the welfare of residents. Maybe you live with a group of people and some of them are special needs and you feel like they're not being heard. Well, it's hard to get involved in people that you're not really affiliated with, especially if you're not part of the care team. But there's nothing wrong with calling the number down there and finding an ombuds to check that situation out, is there? Maybe you're not worried too much. Maybe they're not like, well, I don't really think abuse is happening, but I really feel like these people are not having their needs met. Well, there's a phone number right there. Highlight it, keep it. Remember that number. You don't have to memorize it, but maybe plug it into your phone if you're going to be a caregiver, because you might call an ombuds sometime and get them out there for somebody that needs one. Hero. And then there's the other website as well. So on to the final page, 73. There's also Disability Rights Washington, the DRW. And that's a nonprofit organization that protects the rights of people with disabilities statewide. They're sort of like an umbrella organization that just sort of like watches out for people that might need a little extra watching out for. Okay, we take care of the people that need taken care of. They provide free services for people who need like the rights that maybe don't know the rights of folks who are disabled. Technical assistance for people who have disability issues, general information about legal rights, strategies to self-advocate, ways to empower people with disabilities, community education, and legal services. There's a phone number and there's a website there. That's the kind of place that you would call if you feel like your client might need something that they don't have for their safety and well-being. Like, for example, a shower bar in their shower. Maybe they really need a walker and they can't afford one. Maybe you'd call these folks and say, hey, I've got a client who's disabled. They really can't leave their house, but if they had a walker, they could. Watch how fast a walker appears in that client's home. Okay? These people really do a lot of good. I've dealt with them in the past. They're fantastic. They're focused on helping the community and doing the most good. So great people. Reach out to them if you need some assistance in helping your client accomplish something. So in summary, all the clients have the right to live free from abuse, neglect, and restraints, and advanced directives legally protect the client's right to make decisions if they ever become incapacitated. Okay? Lots of information. We covered this one. Very good chapter. Let's flip over now to page 74 so you can take a quick look. I'd like you to fill out the checkpoint information. Answer these questions as best you can. We'll go over these in class, of course, and then complete the module review. Not cheating on the test, right? Don't look at the answers. Just fill the answers in best you can. If you miss them, we want to know why you missed them so we can explain them away. So there we go. We've wrapped up module 4. Thanks for hanging with me through that. I will see you guys at Module 5, and you have a wonderful afternoon.